It's already time to start the meeting. We've also formed a quorum, so please invite the administration to join us. Since middle of June, we have received a number of such orders, but then as a result of the severe clashes of meetings towards the end of the session, we were not able to deal with them. Moreover, for such sanctions, they have become effective administratively by way of gazettal notice. So what has happened is that we are merely voicing our opinions afterwards. So there isn't any time-sensitive element, and it won't be barred from coming into effect just because we're not able to get to them. But it's not good to accumulate too much backlog. Mr. Dennis KWOK, you wrote to the subcommittee on the 17th of June. The paper is contained in our paper numbers 1347/12-1301. Would you like to walk us through the paper? I haven't actually received a satisfactory reply from the administration, but I can follow this up on other occasions. Well, once the letter has been issued, it has got a life of its own. It's not up to you to say that you would give up following this up. What about the other two members in relation to Mr. KWOK's letter as well as the admin's reply? Would you like to start a discussion? No, then in this case, you may want to follow this up on other occasions. Well, before us, we have the following regulations. The one concerning Iran, Côte d'Ivoire, Eritrea, Somalia, Libya, and, let me check, Sudan. So altogether, six of them. We have 3.5 hours, but I won't be that optimistic that we are able to cover all the 6 of them, although it has become quite a routine job. We'll try to cover as much as possible, and then we will arrange for a second meeting. First of all, let's deal with the sanction order against Iran. Let's deal with them in the chronological order. It was sent to us on the 11th of June 2013. So paper CB bracket 1.309/12-13/01. So administration, please walk us through the sanction order against Iran. Who would like to start? Probably I need to introduce the representatives first, though we are quite familiar with you. Ms. Carol Yun, DS for Commerce and Economic Development. Mr. Raymond Wu, PS for Commerce and Economic Development. And then Ms. Alice Choi, Senior Government Counsel. In the second row, Ms. Ronnie Ng, Senior Government Counsel. Ms. Mandy Ng, Acting Senior Government Counsel, both from the Department of Justice, as well as Ms. Michelle Fung, Government Counsel from Department of Justice. How come that you have such a strong team? Usually we have 2, but then for a particular agreement, we have different lawyers for the 2 versions, the Chinese and the English versions. Well, we have the International Law Division as well as the Drafting Division being involved. Last time, it so happened that there was Anna who was present. Well, this time we have got a Chinese draftsman, so we're supposed to get 4 of them. That's the normal arrangement, 2 to 3. Ms. Yun, please walk us through the Iranian sanctions regulation. Madam Chair, as you have said, there are 6 regulations and 1 for the purpose to repeal. When it comes to the details, I'll invite my colleague, Mr. Wu, to talk about individual ones. Maybe Mr. Wu can give you a briefing on the Iranian sanction regulation. I would suggest that we go to the marked up copy. I will base on the English version. If necessary, we can go to the Chinese version as well. Which one? Annex F. So please walk us through the legislative brief first. Certainly, Madam Chair. First of all, for the UN Sanctions Iran Amendment Regulation 2013, let me talk about the background. Iran is a country in the Middle East. It is a signatory to the Non-Proliferation of Nuclear Weapons Convention. But then we have imposed a sanction order against Iran in terms of financial services and other weapons because of the use of uranium. And as a result of the UNSC 1929, we have a list of sanctions. And the CE has to implement the order. And as a result, we have made the relevant sanction regulation. In year 2010, Iran ranked 50th in relation to our World Trade partners. We have a trade volume of $3.5 billion. $290 million worth of goods come from Iran, mainly fruits, and then we export materials, mechanical equipment, etc. to Iran. The trade doesn't involve anything like firearms, and therefore we believe that the sanctions against Iran won't be having a very serious trade impact. So that's the background. Anything to ask about the background? If you have followed the international news, then you know that there are still talks underway. It appears that we may be expecting some breakthrough. Let's hope that maybe as a change of the government, there may be new developments. All right, that takes us to the crossfire and cross-scrutiny. Mr. Wu, please. I suggest that we go to the Chinese version of Annex F. It's a marked-up copy. For the UN Sanctions Iran Amendment Regulation 2013, we have got 11 clauses. And in fact, we are updating the list of sanctions as a result of the UNSC's decisions. We take this opportunity to carry out some textual amendments so that they are in line with the recently endorsed UN Sanctions Amendment Regulations. First of all, please take a look of Clause 1 or Section 1, Interpretation. We are making amendments to things like regulated prohibited item. In line with the UNSC's decision, we are updating the serial numbers. If there aren't any questions, then I would move on to the next place for amendment. So there's about changes about the year as well as the serial numbers. All right. The next one is not in the Chinese version, it's in the English version. So please take a look of 3A and then A and B, etc. I'm using 4 to replace the phrase in the case of. So it is a technical amendment. Members, any questions? Madam Chair, again, English version, another textual amendment. 5, bracket 2A, small a, all the way up to small e. Again, we use 4 instead of in the case of. Again, it's a textual amendment. If I may ask a question, in relation to this change of diction, I want to know whether you are going to apply the same to other regulations. That is, in future, whenever you have in the case of, you will change it to 4. I think the drafters would like to have consistency. So once we have used this one, now we're going to use it in other laws. So would it be the case across the board? I want to know whether this is the first time or whether it has already been done in other amendment exercises. Well, we are using 4 to replace the phrase in the case of. Whenever we do anything new, this is in line with the trend of using plain language. This is not the first time that we see this, no. Well, I think we need to be careful. If we're to start a precedent and if we are careless, then of course the administration would then hold us responsible in the future. Mr. Wu, please. Madam Chair, for the next amendment, you can go to 6A of the Chinese version, bracket 2. In a number of places, 彈道導彈技術 is being used to replace the term 彈道導彈 because we want to align it with ballistic missiles technology. So the word technology is being added in Chinese. Thank you. Next one, again English version. AgendaI capital letter brackets 9. So instead of a full stop, we have a semicolon. This is to align with the Chinese version, and that's in the prohibited person and the specified between the prohibited person and specified commercial activity. We have a semicolon replacing a full stop. Madam Chair, next one, 9, bracket 3, bracket small a, and also bracket 4 under 9. Like before, we are following the decisions of the UNSC so as to make changes to the serial numbers and the years. And then section 10 of the Chinese version, we use 有關 to replace 第一款提出的. This is a technical amendment. Why? I think it's better, clearer to talk about referred to in subsection 1. Why is it that we've got a similar amendment? Well, we see similar textual amendments in other amendment regulations as well. Perhaps the drafters may want to explain this further. Madam Chair, in the Chinese version, when we say 有關, it means that it has been mentioned before. In other words, there is always a first mention prior to that. So this sort of drafting is to make it clearer. However, we have to strike a balance. When we refer to it the second time, third time, or fourth time, and we still have the whole thing being spelled out, it looks clumsy. Therefore, I believe that for this one, it wasn't drafted by me personally, but I assume that this is for the purpose of clarity. Any questions? I think it's clearer without the change, but I don't know whether you are referring to it for the first time. It's better to refer to the specific section or subsection. In the Chinese version, we are using 6 characters only. Now you're using 有關. The reader may not be too clear as to which is the relevant subsection, so it's better to specify the subsection. There must be a prior reference before we resort to the word 有關. So it won't appear out of nowhere. Mr. Kenneth Chen, I think we need to go to 10 bracket 1. It refers to subsection 2. It is there in both Chinese and English versions. So subsection 2 is mentioned there, and we do expect the requirements. So even though we are striking out referred to in subsection bracket 1, I think the two subsections are very closely related, and I believe that such a drafting is acceptable.
However, I won't agree. It is not that you have got already 10 lines, and so it looks cumbersome, so you just want to say relevant or above mentioned in order to simplify matters. However, you're only using 2 characters to replace 6 characters, and it doesn't help a lot with clarity and simplicity. I think you are muddling through, you're making things muddled. I would stand even firmer in other bills. But of course, we can only make the comment, and it is up to you to make a decision. Okay, Chairman, we will go back and again consider this. We will try to see what we want to do with the next regulation. Okay, please continue. Next one. 11(2) Chinese version. 2 changes. Again, we replace 第一款提述的 with 有關. This is 11(2). As I said, 有關 replaces 第一款提述的. And then in small b, we have changed the enumeration of documents according to the decisions of the Committee of the UN. We'll ask the administration not to do the same thing with other bills or drafting exercises. 24B, a Chinese version. Two amendments. First, bracket 2. We use the words 該文件 to replace 該等文件, and then bracket 3. We have added the words 任何 between the words 須向 and 按照. So 2 words have been added. Those are the 2 textual amendments. In Chinese, 該 and 該等, are you going to do the same thing from now on? We will try as much as possible to maintain consistency for all the regulations. We have made this change because 文件 format 或物件 are displayed in an either-or fashion and not in an and fashion. So we don't use the word 等 because any one of these will do. We think that the present drafting is all right, and we will do the same from now on. I think you're talking about the singular or plural construction. Is that right? Did you do any changes to the English version? No. Sorry, I'm only using the Chinese version myself. Our LA says there is no change to the English version. No. Okay.
Okay. 主席，下一條
Chairman, next one. 32 in the Chinese version. This is about getting access to documents of the Security Council. We have added a checklist of those documents for public access. Chairman, with regard to the UN Sanctions Iran Amendment Regulation 2013, those are all the changes. What about the explanatory note? It reflects the purpose of the amendment. It is not part of the legislation. It just tells people the purpose and the target to be achieved with this amendment. Okay, members, any questions about this regulation? If not, then we can go to the next one, which is Côte d'Ivoire. We will again do as what we did just now. We will have a briefing of the background, and then we will talk about the existing condition, and then we will go to the regulation itself. Côte d'Ivoire is a country in Western Africa. It became independent some years back, but then there are still many controversies around its boundary. In 2009 December, the UN passed the UNSCR in order to impose sanctions on Côte d'Ivoire. But then the UN is happy that there has been some positive development in that country, and therefore the ban on the transfer of armament has been relaxed. Therefore, according to the relevant UNSCR, Hong Kong is, of course, also obligated to impose sanctions as according to the resolution. And therefore, we have got this regulation. However, since we have a very small volume of trade between us and Côte d'Ivoire, and therefore the Census and Statistics Department has hardly got... Sorry, I made a mistake. It should be Côte d'Ivoire. Sorry, I said the wrong name in Chinese because all the regulations sound the same in Chinese. Well, but we know that there is a football team from Côte d'Ivoire. Sorry, let me start again. Right, this is paper CB bracket 1 1525 bracket 01. Côte d'Ivoire is a country in Western Africa. It became independent in 1960 from France, but then it was involved in some coup d'etat and also internal strife, and therefore starting from 2004 the UNSC has imposed sanctions on this country. And in April 2013, it passed Resolution 2101 to extend sanctions on Côte d'Ivoire, especially the sanction on the ban on import of unprocessed or rough diamonds. And this will be valid until the 30th of April 2014. And then the chief executive has received the instruction from the MFA in order to make regulation to entrench such sanction. I like to say that there is a relevant regulation on Côte d'Ivoire every year, and it automatically lapses at the end of the year. So we are just reenacting the same regulation for it to become effective this year. Actually, Côte d'Ivoire is the 134th trading partner of Hong Kong, and the total trade volume is only $134 million. And since it is a small volume of trade, and since the goods involved are not banned exports, we believe such sanctions will not make any major impact on the trade between the two places. I'd like to give you some information. The so-called sunset clause, does it only apply to Côte d'Ivoire or all the other sanction regulations? Well, in fact, it is present in some other regulations as well. Every year we have to deal with about 3 to 4 such sunset clauses, and they, in a way, invalid the regulation automatically. So basically, this is the same as the one last year, only the date has been changed. Chairman, if you allow me, I'll go through the regulation. The 2013 UN Sanction Côte d'Ivoire regulation, there are 32 clauses, and it is based on the invalidated UN Sanction Côte d'Ivoire Regulation 2012. Now, what are in these regulations? The first one is interpretation. It defines certain terms in the regulation. And sections 2 and 3, they prohibit the supply, sale, transfer, and carriage of arms or related material to Côte d'Ivoire or certain persons connected with Côte d'Ivoire. Section 4 prohibits the importation of rough diamonds from Côte d'Ivoire. Section 5 provides for prohibition against making available to certain persons or entities funds or other financial assets or economic resources, or dealing with funds or other financial assets or economic resources of certain persons or entities. Sections 6 and 7, just like those last year, provide for prohibition against the entry into or transit through the Hong Kong SAR by certain persons and relevant exceptions. Sections 8 to 10 are the same as those last year, provide for the granting of licenses for the supply, sale, transfer, or carriage of prohibited goods, for the importation of rough diamonds from Côte d'Ivoire for the purpose of scientific research and analysis approved by the committee, and for making available to certain persons or entities funds or other financial assets or economic resources, or dealing with funds or other financial assets or economic resources of certain persons or entities. And then we have parts 4 to 7. Those have to do with investigation and enforcement powers. The relevant sections are the same as those in other regulations. Section 30 and Section 31 provide for the Chief Executive that the Chief Executive may by notice published in the Gazette specify as a relevant person or a relevant entity a person or an entity designated by the committee for the purpose of the financial sanctions under Section 5 of the 2013 regulation. This is present in all the regulations. Section 32, it only targets Côte d'Ivoire. It provides that the 2013 regulation will expire at midnight on the 30th of April 2014. Any questions? If not, we go to the third one. United Nations Sanctions, Eritrea, Amendment Regulation 2013. I just looked up the Google map and I know that it is next to Saudi Arabia. It is below Sudan and Egypt, and it is above Ethiopia. Okay, we use the same format, please. Sorry, I beg your pardon again. Eritrea. Eritrea is a country in northeastern Africa. It became independent in 1993. As I said, it maintained a very tense relationship with its neighbors. And starting in 2007, it started to provide a lot of support to the rebels in Ethiopia. And therefore, there have been a lot of sanctions imposed on Eritrea. But then the UN welcomes the positive developments, and therefore, in July 2012, it passed Resolution 2060 to relax certain sanctions. And the CE has received instruction from the MFA to make regulation according to Resolution 2060 to impose sanctions. Since the volume of trade between Hong Kong and Eritrea is so low, the Census and Statistics Department does not keep separate figures for that trade volume. Basically, Eritrea and other African countries would be subsumed under African countries' territories. Now, for this particular group, they rank 194th as a trading partner for Hong Kong. And altogether, the trade volume is only 4.7 million Hong Kong dollars. Since it's such a small volume, and since the trade in goods has nothing to do with arms or armament, we believe there will be very minimal impact indeed posed by this sanction. Do any Hong Kong people go there for sightseeing? Because with regard to Yemen, Ethiopia, no people actually go there for sightseeing. Do people go to Eritrea? Chairman. Chairman, I actually do not know whether Hong Kong people go there for sightseeing. But between 2010 to April 2013, we do not have direct flights from Hong Kong to Eritrea. But whether people have to go via other countries to Eritrea, we do not know. We understand that people do go to places around Eritrea. So I'm asking you if people should bypass Eritrea, and if they meet up with any accidents, what we can do. I can see that they have an embassy in Hong Kong. Okay, okay.
Madam Chair, if you permit, if I may go to the different clauses. Again, I will make use of the Chinese version as the basis. In other words, Annex F, correct. UN sanctions retreat regulations, the amendment regulation 2013, there are 18 sections. It was based on UNSC resolution 2060. This is to provide for some exceptional cases, and we have also taken the opportunity to have some textual amendments so as to align them with the recent exercises of a similar fashion. If I may go through them one by one. Section 1, interpretation, some textual amendments. First of all, Chinese version, person connected. In the definition, we have taken away the two characters, 任何. For designated person, instead of 指明人士, we use the term 指認人士. Any questions, members? No, then we'll move on. And then in 9A and 9B, we have added some clauses, and therefore we have also made some changes to the definition of license, 特許. And then in interpretation, in the English version, we have also made a textual amendment. Any spare part for will now replace any spare part of, so the word for is being used to replace the word of. Any English teachers around? So we're not going to dig into that. We use of to replace for. Any spare part of instead of any spare part for. We use of instead of for. You're going to repeat the word of. Arms or related material. So you are removing the word of or for. I think of is being deleted. Sorry, Madam Chair, I was wrong. Your legal advisor is right. We use for to replace of. It's being audio taped. Many years later, it will still be available. Your legal advisor is right. We use for to replace of. Please continue. Madam Chair. Section 2, Chinese version. Because we have added more clauses concerning license, so we have made corresponding changes. First of all, 2.2. We have a 2A being added. This is because the specified persons are not going to benefit from the new license arrangements. So it's only under 2. Will people benefit from the specified arrangement, so they have to be taken out and to be dealt with separately. Any questions concerning such an arrangement? No? Then we can continue. Madam Chair. Let's go to Section 3, Prohibition against carriage of certain goods. A similar amendment has been proposed. So we have a number of them being taken out so as to cover the scenario in which certain specified persons are not going to benefit from the license arrangements. So we've got 2A, 2B under 2. And then a textual amendment in the English version. 3.2a, or rather 3(3)A to E, using for to replace in the case of. A similar change that we have already briefed you about. Madam Chair, if you agree, we go to Section 4, Prohibition against provision of certain assistance or training. Yes, please continue. For this amendment, this is because of the additional clauses about license, so we have to make a corresponding change. In particular, bracket 2, except under the authority of a license. We have made some textual amendments. Chinese version 4, bracket 3, and bracket 4, and bracket 5. So the Chinese version, we say 指認的人 to replace 指明人士. And then 4 bracket 5就違反第2款意見 and 就違反第3款意見. They are replacing 如該人被控違反第2款 and 如該人被控違反第3款 respectively. Again, textual amendment. I want to ask this question. Of course, in Chinese, 指認指明人士 would have an element of passive voice. Many scholars, including university heads and also experienced lawyers, examined the differences between 指明 and 指認人士. Sometimes they have a whole box file of documents considering a particular rendition. So they were very serious about the bilingual versions. Now you are changing 指明 to 指認. So what sort of process have you gone through? Now for law drafting, I think you need to build up the basis gradually, but of course erosion may also take place gradually. So whose help have you enlisted? Or is it simply because the drafters think that 指認 is better than 指明? Did you ever talk to anybody who is an expert in linguistics? Now, since you are starting to change in this way, you will do the same in future, right? Well, for the legal provisions, for 指明, we will call specified. 指明 is for specified. Here, the English version reads designated. So in order to differentiate between specified and designated, we have 指認 and 指明. So I think as long as they are consistently and differently translated, I think it will be fine. Yes, I think there is a slight difference, but I was interested in the process. When you try to tidy up such finer details, I want to know who were involved and whose support have you got behind such an exercise. Madam Chair, in some cases, we'll look at the decision itself, the resolution itself. We'll try to see whether there is a particular rendition in Chinese. If we find it appropriate, we'll try to follow the wording in the resolution itself. In many cases, in the resolutions, designate will be rendered into 指認, carrying a sense of authority. And then, for this kind of sanction regulations, in many cases, we have got different targets in relation to the sanctions. So our consideration was, if a UN committee says that a particular person has to be sanctioned, then we will use 指認 for 指明. We will use that term in other cases. Therefore, are you saying that for 指認, it is a term borrowed from the UN resolutions? Yes, we did make reference to that. For this particular regulation, I haven't actually read the Chinese version of the UN resolution, but in the course of our examination, we did look into this one. Perhaps the AJLS panel members may want to see if this should be followed up. because for the bilingual law exercise, it is a very hard exercise. Chinese doesn't render itself easily to law drafting. I'm worried that if we make a wrong step, it will have far-reaching effects. So perhaps the AJLS panel can follow this up. When we in Hong Kong try to draft laws in Chinese, do we actually have sufficient support? I think it's a question for the AJLSP. Mr. Wu, 5(5). Again, some technical amendment. Now, instead of if the person is charged with contravening, we now say for a contravention of subsection 2 and subsection 3 respectively. Any questions? Madam Chair, English version 6(3) small a to d, again as before, instead of in the case of, we now replace the phrase with the word for. Madam Chair, next one, Chinese version, section 7. As a result of the addition of license, therefore, under 10(2), we have to mention the new or the additional license clauses. Any other questions? Madam Chair, Chinese version, section 8. Again, we use 指認人士 instead of 指明人士 for designated persons. All right, please continue. Similarly, for section 9, 指認人士 instead of 指明人士. Please continue. Part 3. Part 3, if I may mention one point, for the title licenses in the plural form rather than the singular form. Chinese version, we have added 9A and 9B. This is to follow paragraph 11 and 12 of UNSCR 2060. We have the licenses, and therefore we have spelled out the new provisions in 9A and 9B. If I may ask a question for part 3, licenses. Usually we have a singular form. Now, since you have got a different kinds of licenses, and that's why you have to use the plural form. That's how I understand it, Madam Chair. Next, section 10 of the Chinese version. In subsection 2, like before, we have 有關 to replace 第一款提述的. Again, it's a technical amendment. I have the same opinion. I'm not going to repeat my point. Point taken, Madam Chair. Please continue. Chinese version, section 13. Section 3 has been broken into 3(2) capital B. So, as a result, we would like to add the relevant reference so that the relevant authority may carry out the relevant investigation. Madam Chair, we move on to section 16, and that's about the investigative powers. Again, as a result of having added section 3(2) capital B, so we have to add the reference so as to enable investigations to be carried out. Yes, that's for suspected aircraft. Similarly, for transport. So, for suspected vehicles, we need to add the reference to 3(2) capital B. Members. Aircraft, vessels, vehicles who have investigative powers. In fact, during the last term, Ms. OGG and Ms. Margaret Ng has had a very detailed examination about such matters, and I think it will be safe.
嚟緊去到中文文本嘅
Next one, 25 bracket 2 and bracket 3 of the Chinese version. We use 該文件 to replace 該等文件 and we add 任何 after 須向. This is a textual amendment. Okay. Chairman, last but not least, 32 in the Chinese version. We use 指認的人 to replace 指明的人. Alright. I think that's it for the UN Sanctions Eritrea Amendment Regulation 2013. Next, Somalia. Chairman, can I please take you through the background of the country? It is in Eastern Africa. It became independent in 1960. But the relevant president was overthrown in 1991 and anarchy ruled. Therefore, since 1992, the UNSC imposed various sanctions on Somalia. According to the agreement reached by the various factions in Somalia in 2008, there would be a coalition government formed. The Security Council confirmed that in this past period, Somalia had made huge progress in terms of security, but it is still aware that the country still poses threats on its neighbors. And therefore, Resolution 2093 was passed in March 2012 in order to provide exceptions on the ban on armament transfer. And also, it relaxed certain criteria on the designated persons. And in April 2013, the CE received instructions from the MFA to entrench a regulation in Hong Kong according to Resolution 2093. In 2012, in terms of trade, it ranks 152, and the trade volume is only over $60 million, and we mainly import leather from Somalia. Since this has nothing to do with the prohibited trade items, and also since the trade volume is small, we believe the sanctions to be imposed on Somalia will not have a big impact on the trade with Hong Kong. Chairman, can I now go into the actual regulation? This is in Annex E of the paper. UN Sanctions Somalia Amendment Regulation 2013 has 9 sections. This is according to UNSC R 2093 in order to provide for exemptions with regard to the transfer of amendment and also the relaxation of, extension of criteria for designated persons. We believe that the writing of the regulation is consistent with other regulations. First of all, interpretation. With regard to the definition of relevant persons, we have crossed out certain phrases. This is because in our second meeting of this subcommittee, Chairman, you have said that we should cross out the relevant words, and so we have accepted the view, and we have also amended the definition of designated person to reflect new exceptions to the arms embargo, and also to expand the criteria for designation. And also, with regard to certain resolutions, since these have been mentioned in the resolution, we have defined these in the interpretation clause. Chairman, we can go to 2(5) of the Chinese version. This is more or less the same as other regulations. We are going to use 就違反第2款而言 and 就違反第3款而言 to replace 如該人被控第2款 and 如該人被控第3款. I think this is the same as regulations that we have already studied. The next one, English version. 3(4) 5, A to E. Again, we use for to replace in the case of. This is the same as regulations we have already looked at. And then Chinese version 3 bracket 7. Again, we use 就違反第2款而言 and 就違反第4款而言 to replace 如該人被控違反第括弧2款 and 如該人被控違反第4括弧第4款. Again, this is technical and textual. Then Chinese version 4 bracket 5. This is the same. To make use of 就違反第括弧2款而言 and 就違反第括弧3款而言 to replace 如該人被控違反第括弧2款，如該人被控就違反第括弧3款。Again, this is textual and technical. Please continue. Yes. Chairman, 8 bracket 2 Chinese version. We are making amendments in order to reflect Resolution 2093 and Paras 36 and 37 to provide for new exemptions with regard to the ban of armament transfer. So we are including these in the regulation. And then in 8 bracket 2, again, we have a textual amendment. We use 有關 in order to replace 第括弧1款提述的. Yes, please continue. Clause 9. Similar arrangements. According to Resolution 2093, there are new exemptions, and so we are adding these into the regulation. And also at the start of 9 bracket 2, we use 有關第括弧1款提述的. Is Hong Kong involved in such shipment or transfer? With regard to Somalia, we have not received any such application. Now, this is not related to the scrutiny work here, but recently it is found that about 20-odd units of yellow explosives have been seized in Taiwan, and that has escaped the attention of our Customs and Excise Department. This was in the news last week. I would ask government departments to communicate better. And also, the Customs and Excise Department should check exported goods more seriously. I think there is a problem here. Chairman, clauses 8 and 9. We talk about the African Union strategic concept. What is this? We can go back to interpretation. The African Union strategic concept. May I invite my colleague from the International Law Department to explain? This means the AMISOM can be sent into Somalia in order to maintain order, where AMISOM is defined. But what about the African Union strategic concept? This is in capital letters. Does it have a definition? No. What about in the UN document? Do we need to define it in our local regulation? Mr. Wu, Chairman, thank you for the question. I am aware that AMISOM is defined. Now, do we need to define this as well? Actually, the Somalia regulation is amended from time to time. We will take this back to discuss with our drafting division to see whether we should define African Union strategic concept. Now, could you assist us, please, and let us know? Where in the UNSC resolution we can see this strategic concept? Can you assist us with that?
如果睇返第20
If we look at Resolution 2093, para 36. 36D. We are following para 36 of the resolution. AMISOM is an acronym. So we have got the definition there. But the African Union Strategic Concept of 5th January 2012, there is no definition either in the resolution. So we just follow the resolution. But do you know what it is? Even if there is no definition. Chairman, as our colleague explained, we have not got a definition here because there is not such a definition in the resolution of the UNSC. Now, is it worth our while to come up with a more proper definition in another context so that the concept is clear in our resolution so that users know what it is about? I think we can go back to discuss with our drafting division and report to you afterwards. This regulation is for local entrenchment of international conventions, and this can happen on other occasions, and the administration would always try to transport what is in an international convention into local law. I thank Mr. Dennis KWOK for asking the question, so you can ask the question of the United Nations. I thought you knew, but actually you don't, and this is already in our resolution, our regulation. I think this is not very proper. Well, it is a paper, right? We mentioned the sanctions resolution right in para 36. For example, it does mention the African Union Strategic Concept, and there is a date. Yes, it is actually a paper. It should be a paper. Because usually, I think members will know this, if we use capital letters for a certain word or words, and if there is no definition in the law, there may be a problem. People will ask the question, and you cannot assume that people will go back to the UN resolution in order to find out what it means. In the English version of our own regulation, do you do what the UN resolution does, and that is to use capital letters for these few words? The LA says yes. But in Chinese, we cannot see any capitalization, and so we don't know whether it is a proper name. Chairman, if we look at the English version of the resolution, indeed, capital letters are used, and also there is a date following it. Therefore, we believe it should be an understanding or a paper reached on a certain day. But as Mr. Wu said, we could see whether there is a need to explain this term to make things clearer. Okay, thank you. Please continue. Chairman, 10(2) Chinese version. Again, like before, we use the words 有關 to replace the words 第括弧一款提述的. Okay, please continue. Next, Chairman, the last one, 32. It provides for certain exceptions, and also that it is limited as to the validity period. It will only be at 12 midnight on the 5th of March 2014, and this is in relation to 82E and 92C. Okay, that's it for the regulation. Any questions? If not, we go to the next one.
So we go to the one concerning Sudan. Madam Chair, if we adhere to the agenda, I think the next one should be the one about Libya. Sorry about that. Yes, you're right. Madam Chair, if I may have a brief word about the background. It's a country in northern Africa. In 1951, it achieved independence. As you know, that since 2011, there have been a lot of conflicts, and there was the involvement of the army. In February and in March, respectively, resolutions 1970 and 2011 were imposed, and there was a no-fly zone as well as other sanctions like arms embargo, travel ban, etc. In the light of the improvement in the situation, the UNSC in September 2011 Resolution 2009, as well as another resolution, that is 2095, were passed so as to lift the requirement like the no-fly zone. Libya's latest positive arrangements are welcome. Therefore, UNSCR 2095 was adopted by the UNSC on the 14th of March 2013 to lift the requirements. The CE received instructions from the MFA so that we have to give effect to UNSC Resolution 2095 in respect of Libya. And in 2012, Libya ranked 147th among Hong Kong's trading partners in the world with a total trade of $88.3 million. We're mainly talking about shoe, footwear, and also electronic goods. Since they have got nothing to do with firearms and the trade volume is small, so we believe that the current sanctions would unlikely to be of any special effect on the trade between Hong Kong and Libya. Madam Chair, there are 8 clauses in relation to the UNS Libya Regulation 2011, Amendment Regulation 2013. This is on the exemptions in relation to the original regulation. We take this opportunity to carry out some textual amendments so that they are more in line with the drafting style of recently adopted regulations. Madam Chair, again, please go to Annex E. We would like to look at the English version 3, 4A and B, instead of in the case of we have 4. And then again, English version 6 bracket 3, small a to small e, again for replacing in the case of. Please continue. And then Chinese version. The Chinese version, please go to 7 bracket 4.就違反第2款而言，如該人證明本身既不知道沒有理由相信 as well as 就違反第2A 款而言，而該人證明本身既不知道亦冇理由相信 to replace 如被控違反第2款。而該人證明本身既不知亦冇理由相信 and 如被控違反第2A 款，而該人證明本身既不知道冇理由相信。So again, this is a technical and textual amendment. Members, any questions? No? Then please continue. Thank you, Madam Chair. Madam Chair, the next one can be found in the English version. 11 bracket 3 bracket small a to bracket small c, again for replacing in the case of. Yes, please continue. And then the Chinese version, section 13 bracket 2, we use 有關 to replace 第一款提述的. Again, it's the textual amendment. And then for the subsequent amendments, they are in relation to Sections 9, 10, and 11 of the UNSCR 2095. There are further exemptions, so we are going to give effect to them. The Chinese version is the same. Mr. Dennis KWOK. I think there are certain changes in paragraph 2CA. You mean the English version? The prohibited goods are non-lethal military equipment to be supplied, sold, transferred. You can find it in the Chinese version as well. And then for D, the prohibited goods are not non-lethal military equipment. Please explain the difference between CA and D. Should the focus be on non-lethal? Maybe our colleagues from the international law can explain. This is a new exception for non-lethal military equipment. The difference between CA and D is that for CA is non-lethal military equipment. For D is all other non-lethal military equipment. So you have not non-lethal military equipment. Not non-lethal military equipment is not the same as lethal military equipment, if that is what is in your mind. Yes, it's a bit complicated. For the arms embargo, it's on arms and related military equipment. So other than military equipment, we still have arms. So if you just carve out non-lethal, you still have lethal arms and non-lethal arms and lethal military equipment. That's why we have to draft in this way instead of just saying lethal military equipment. I think the Chinese version also reads clumsily. If you take a look of CA and D. Please continue. Section 14. Similarly, we have included additional exceptions in light of paragraphs 9 to 10 of the UNSCR 2095. And then in 14.2, the Chinese version, we say 有關 instead of 第一款提述的 relation to referred to in subsection 1. Any questions? Mr. James Toh, if I may ask a question about B. Instead of 利比亞當局, it is now 政府. Why? This is in response to the UNSCR's change. The last time that it was made, it was transitional, and so the UN called it the authorities, 利比亞當局. Now it has made the transition successfully, so we have a new government there. So this is to respond to the change of the wording on the part of the UN. Well, this is sanctions, embargo. In other words, there are certain things that could not be handed over to them owing to one reason or other. So I can appreciate that you have spotted a change in the words used by the UN. Must we follow suit? If you ask me, I would say that perhaps in the past it was a transitional government or the opposition. So at the time you call them the Libyan authorities. Now you call it government of Libya. But then things are not that stable. Not that I wish that it is unstable. But I want to know whether it will be safer to use authorities so that one day when it is overturned, but of course we may want to lift the sanctions. In that case, but what worries me is that must you change. Now the UN saying that this is the formal government, and so you want to change it. So do you anticipate further changes in the future? Mr. Wu, thank you, Mr. James Cho and Madam Chair. We took into account the prevailing circumstances as well as the wording used in the UNSCR and the targets of the sanctions for the Libyan authorities and government of Libya. They are different. This is because when the Libyan authorities were first mentioned, it was still a government in transition. Now there was the Liberation Declaration, and with the death of the leader, the UN is now calling it the government. And since there has been a change in the use of words on the part of UNSC, so we are changing correspondingly. Even if we don't change it, I think it can still cover the current government. Am I right? Ms. Choi, if I may explain, for us to implement the UNSCR, to a certain extent, we are restricted. We don't have room for our own interpretation. If the resolution contains a certain wording and if it is targeted at certain personnel, we have the duty to follow suit. Just now, Mr. Wu has explained that we are using a new phrase and there is a background behind it in the light of the latest development. If we start to apply our own interpretation and try to expand the meaning of the phrase to include organizations which we do not know may or may not exist, then we'll be exceeding our powers. In the resolution, as a result of the changes to the organization, the resolution has changed its reference, so it is more proper to follow the same reference. Thank you. I think this is the license, and we're talking about the exceptions. If the government is overturned, and then there won't be any exceptions, so it is a tightening up. So you don't need to worry that the different tribes in different quarters of the country will be given the arms. 15(3). So the same point. Instead of authorities, we have got the term government of Libya. Madam Chair, we don't have any other proposed amendments for the rest of the regulation. So for this regulation, do you have other follow-up questions? If not, then we can really move on to the one concerning Sudan. Thank you. Thank you, Madam Chair. If I may briefly talk about the background. Yes, Mr. James Cho. I've spotted a word which covers quite a wide scope. I want to know about your requirements. Which one? The one concerning Libya. 2(b). You said that unless there is a license, you can't export that item to Libya. But then you talk about to a person connected with Libya. Connected. Do you have a definition for the word connected? Yes, it is covered in the interpretation. Persons connected with Libya means the government of Libya, any person in or resident in Libya, anybody incorporated or constituted under the law of Libya, anybody. Where can I find it? In the interpretation section. At the front, yes, section 1.
Let me take a look.
Just control. Oh, okay, coming up.
Okay, fine. It is quite narrow as it is constructed, but if it is just a general term, it is too wide. All right, okay, that's it for Libya. Any more questions? If not, let's go to Sudan. Chairman, let me introduce this country. It is in the northeastern part of Africa. It declared independence in 1956. However, it was plagued by internal strife. South Sudan in 2011 became independent from Sudan, and starting from 2003, Sudan government and other civilian forces had a fight in Darfur area, and the UN was aware of the possible threat that Sudan imposes on other countries. It passed a resolution in March 2012, and in June 2013, the CE received instructions from the MFA to make regulation in Hong Kong in order to impose sanctions on Sudan according to UNSC 2035. Actually, Sudan is 128th partner of Hong Kong in terms of trade, and the traded volume is $154 million, involving mainly leather goods, and such goods have nothing to do with the armament ban and sanctions. So this sanction regulation is not going to affect Hong Kong's trade. Any questions on the background, please? Chairman, we are going to repeal the existing regulation and replace it by a new regulation. As I said, the sanction does not cover a big area this time around, but since the existing sanction on Sudan was made in 2005, the words used may not be the same, and that is why we have adopted recent constructions in order to replace the old resolution. Therefore, we have the new regulation as well as the repeal regulation. There are 23 sections. This is made according to the UNSCR 2035 and previous UNSCRs. These have to do with the travel ban and arms embargo, etc. I'd like to introduce the sections. Section 1, commencement date. It provides that the 2013 regulation will come into operation on the 6th of September 2013. Section 2, interpretation. To define certain terms in the regulation 2013, including words that you can see in different regulations, for example, economic sources. Sections 3 and 4 prohibit the supply, sale, transfer, and carriage of arms or related material to certain persons connected with Sudan. Mr. Wu, could I ask our LA a question? Because actually, the clauses, well, you refuse to give us a template in order to make such regulations, but then we see that in the actual operation, this is what you are more or less doing. Because the surge, banning of transfer or sale, etc., you actually follow the same kind of approach in drafting such regulations. So I'd like to ask our LA, since she has checked the regulations on our behalf before today's meeting, I'd like to ask her whether the diction is consistent with other regulations. Yes, it has followed the new kind of diction for such regulations. Okay, so this is to provide information to members. Since we are having a new regulation instead of having a marked up copy, actually the diction and the approaches are consistent with other sanctions regulations that we have studied. So we don't have to go through the regulation here line by line. Please go on, Mr. Wu. Thank you, Chairman. I'll continue with Section 5, which prohibits the provision of assistance or training related to the provision, manufacture, maintenance, or use of prohibited goods. As the Chairman and the LA have said, A similar prohibition clause is present in other regulations. Mr. James Toh, I asked a previous question about Libya and persons connected with Libya. Here, I see you have a totally different definition. Is it that you are not copying it? Because in the Libya regulation, it is much wider.
Any person
It says any person that lives in Libya. No. And also, the companies that set up in Libya. But here, you allow this to be done to a person living in Sudan. Why is it different? Yes, Chairman. Mr. James Toh has made a very valid point. Actually, in persons connected with, in most regulations, they would follow what we saw in the Libya regulation. But this one in the Sudan regulation, it is indeed a little different. This is because we have aligned it with the resolution. No, sorry. Please explain a little. If this is the case, now if I may make a comparison. Any person acting on behalf of the government, you can still allow that to be done. Have you missed out on anything? I know there is a ceasefire agreement. Then any persons acting on behalf of the parties to the ceasefire agreement should be included. However, they are not. Is that deliberate? Mr. Wu, what about the UN resolution? If this is exactly what the UN has done, then I could only assume that the UN has given it some thought. But if that is not the case, then you have to be very cautious. I'd like to add something. Sudan is not the same as other countries because the armament ban has to do with the places themselves, for example, to Iran or to Somalia. But for Sudan, you do not look at the place itself, but only not to those people. The ban is against the people, non-governmental entity or individual. So you're talking about the parties, organizations or persons. Yes, that is the way it is listed. But do you have the same concept as in E of the Libya regulation? Any person acting on behalf of. Actually, here in the Sudan regulation, ABC would align quite well with what is in E in the Libya regulation. Let me explain. Actually, a wider concept is adopted here. As Michelle said, the entire sanction may apply to the place, so it would include persons in that place in order to make sure that the relevant ban will be comprehensive and enforceable. The definition would be much wider to include the government, any persons living in that place, and also anybody incorporated or under the control of the government. However, for Sudan, the UN is quite specific in imposing the ban. Only certain people in a certain place instead of also the people controlled by these people. And that is why in this regulation, we do not include people controlled by people who are targeted. This is the main reason why. As Mr. Toh said, this is because the styling of the UN resolution is such, and that is why we do not want to go beyond what the UN has required us to do. Chairman, can I ask a last point? Does it mean that the A to E under persons connected with Libya, you have copied entirely from the resolution? And also here, A, B, and C, you have also copied from the resolution as it is. Is that right? Well, I think what they do is cut and paste. If that's the case, you talk about persons, but then in Libya, you have A to E, persons connected with Libya. But here, you talk about only persons. And you should actually include any other person acting on behalf of these persons. I think that is usually the case, and this is about legal drafting. Please allow me to add a little. In the Sudan sanctions regulation, the people targeted will be a little different in different areas, but then we always follow the resolution. In terms of the armament ban, Mr. To, we have followed Resolution 1556, paragraph 7. But as to whether we target people who are controlled by certain people, well, with regard to economic sanctions, we have also followed the resolution to include the meanings owned or controlled. So the new regulation actually reflects those two approaches. Mr. To, but do you understand it, Chairman? Have you understood what is said? But you seem to be saying you follow exactly the resolution and sometimes you don't follow exactly the resolution. Is that right? No. Actually, we always follow the resolution to the letter. Well, they dare not depart from the resolutions. This is because, with regard to different sanctions, there are different regulations in the resolution. That is why we would only follow the areas designated by the resolution and reflect them in the regulation. There are different sanctions like economic sanctions and other sanctions, and there are different areas. That is why the construction is also different here. Now let me try to see whether we can assist other members. In English, person connected with a certain country. Even if the same term is used, however, in UN resolutions, the same term may mean a bigger scope or a smaller scope. In making local legislation to entrench the UN resolutions, according to the logic of the administration all along, they have to copy the text and definitions and scopes of the UN resolutions. So all along they have been doing a cut and paste job, so nothing more, nothing less. But apart from sanctions regulations, if we talk about other international conventions, for example, the ban of using chemical weapons, we have questioned the administration whether you really want to do a cut and paste job in making local legislation. This is about our policy in entrenching or localizing our international obligations and conventions. I think this has been a moot point between the legislature and the executive all along. Anything to add from both parties? If not, please continue. Chairman, Section 6 provides for prohibition against making available to certain persons or entities funds or other financial assets or economic resources, or dealing with funds or other financial assets or economic resources of certain persons or entities. Sections 7 and 8 prohibit the entry into or transit through the Hong Kong SAR by certain persons subject to exceptions. Yes. Next. Section 8 prohibits exceptions, or actually provides for exceptions to the prohibitions. Sections 9 to 11. Section 9 provides for the granting of licenses for the supply, sale, transfer, or carriage of prohibited goods. Section 10 for provision of certain assistance or training related to the provision, manufacture, maintenance, or use of prohibited goods. Section 11 for making available to certain persons or entities funds or other financial assets or economic resources. Or Section 12, the provision of false information with regard to the licenses and penalties. And then parts 4 to 8, those have to do with investigative and enforcement powers. And those are in line with the content of other regulations we have studied.
has been confirmed by legal advisor. The drafting is the same. Lastly, sections 31 and 32. It provides that the CP may, by notice published in the Gazette, specify as a relevant person or relevant entity, a person or entity designated by the committee for the purpose of the financial sanctions under Section 6 of the 2013 regulation. So that's it from me concerning the briefing. Thank you. So for this sanction regulation, any questions? Mr. Wu, we have 145 and 146 in relation to the LN. We have finished with the content. But sorry about that, but can you sort of pinpoint the LN involved? Sorry, speaker is off mic. 146. LN 146 is the repeal regulation. Currently, we already have a regulation against Sudan, so that one will be repealed. Any follow-up? Very good. The progress is very good. And for the 6 sanctions regulations, we're able to scrutinize all of them. So we have covered the ground up to the 12th of September concerning the notices. So probably we can sort of rest for quite a period of time. Anything under the way, once we are ready, we'll come back to the LegCo and then we have another round of discussion. If there are more peaceful situations, then less work for us. Meeting adjourned. Thank you.